Good morning, Mr. Maleka. Good morning, everybody.
Good morning, Chair.
Yes, Mr. Maleka.
Chair, today marks the beginning of a different chapter of your mandate that relates to allegations of the state capture project concerning state-owned entities.
Yes.
You will recall that that part of your mandate is articulated in paragraphs 1.4 and 1.5 of the terms of reference. Of course, it is common knowledge that the number of state-owned entities that are affected or implicated in allegations relating to the state capture project. But we thought it appropriate to transition the evidence you have heard thus far relating to paragraphs 1.1 to 1.3 of the terms of reference to this chapter of your mandate by introducing Eskom as the first state-owned entity. We do so because of the fundamental importance of Eskom, not only in relation to our economy, but also in relation to the huge procurement budget that it has and which was targeted in the course of allegations relating to state capture project. I can assure you that we were not the first to consider Eskom as the priority. You will recall that the Portfolio Committee on State-Owned Enterprises of the National Assembly did conduct investigations relating to state capture of different entities, and it too decided to prioritize Eskom in the course of its investigation. May I pause here and read out for you part of the reasons or rationale articulated by the Portfolio Committee when it prioritized Eskom in its investigation. I read from the report, which is part and parcel of the documents presented before you and which I will take you through. For now, Chair, can I ask you to go to volume 3 of the documents that are described as the Eskom Reports.
Yes, I've got it.
I will indicate to you how these documents have been prepared and how we propose to present them before you. But for illustrative purposes, you will see that volume 3 begins with an internal index of that volume. And you will see that the index has 2 items that refers to 2 reports. The first is the undated report, which we describe as the draft report.
Yeah, you're referring to the table of contents.
Yes, Chair.
Yeah, okay.
And the second is the report of the same committee dated 28 November 2018, which we consider to be the final report. There is some difference between the 2 reports, but of no material consequence in terms of substance. It relates to questions of style, formatting, and reduction of volume from one as against the other. But for now, and for the purposes of my introductory remarks, may I ask you to go to internal pagination 0662.
Before we go there, you were at the table of contents. The first report you referred to, is it the one under 1? Part A, and then there's 2 Part B, or is it something else?
Yes, you'll see that the first is item or file number 3. Are you in volume 3, Chair?
I am in volume 3. I am at page 0661, which is the contents.
Indeed.
Yeah.
Indeed.
Number 1 of the contents is Part A, overview of the Portfolio Committee on Public Enterprises Oversight Inquiry.
Yes.
And then there's 1.1 up to 1.3, and then there's 2, which is Part B, thematic chapters, blah, 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 blah. So I just want to identify which one you were referring to as the first report, which one you are referring to as the second report.
The very first one, which begins at page 660.
But in the contents, that's the one referred to in 1 or not in the contents?
Yes, it is the one which is referred to as the Portfolio Committee on Public Enterprises draft report on the Eskom inquiry. You will see if you go to page...
Well, before I go there, I just want to make sure that the content of the table of contents that I have is the same as yours.
Yes.
What you have just read, I don't see in the table of contents. Is it something that's not in the table of contents?
No. The first page of that file will be indexed to Eskom Reports.
Indexed to Eskom Reports, or right at the beginning?
Right
okay,
at the
I've
beginning,
got that, yeah.
yes. Volume 3.
Yeah.
And you will see that the first
report
column
name.
identifies file numbers.
Yes.
They begin from 1 and end at 18. That volume contains file numbers 3 and 4.
Oh, that number there is file number?
Yes.
Oh, it just
because
says number. Yeah, okay.
each of the files has a file divider,
Yes.
which is numbered from 1 to the end.
Okay.
And in the file before you now, you have file dividers number 3 and 4.
Yeah, I've got that.
And you will see that the first divider, which is number 3, is the draft report of the Portfolio Committee. It begins at page...
Yes, I see it, yeah. 0660.
Yes.
Okay. Yes.
It runs up to page 843.
That just before, yeah, just before divider 4.
Indeed.
Yeah, okay.
You don't have to go to any other page except 662 for the present purposes.
Yes.
And this explains why we thought it appropriate to start with Eskom in relation to paragraphs 1.4 and 1.5 of your mandate. We do so, Chair, because it is now publicly reported that allegations of state capture did not manifest for the first time with reference to Eskom, but they came to the public fore in relation to other state-owned entity, primarily Transnet. Eskom was not the first victim of that project, but it is important to deal with those allegations because of the importance of Eskom. And for that reason, we have prioritized Eskom ahead of all other state-owned entities. If you go to paragraph 1.1.1 of that Portfolio Committee's draft report, you will see that the Portfolio Committee started with Eskom in the course of its investigation for the reasons set out in that paragraph. And I ask you to read it with me.
Hang on. You have referred to it a few times as a draft report.
Yes.
Now, I see that at page 0660, there is draft written by hand.
Yes.
Is that what it came with from the portfolio committee?
No.
Okay.
And
So-
we will try and explain to you why we
Yeah.
consider it to be a draft report.
Yes, okay.
I can reveal to you that anecdotally, there have been media reports that a report of the portfolio committee in draft was leaked before it was finalized.
Yes.
And that gave rise to all sorts of difficulties of their own. But they're neither here nor there for the present purposes. So I was at paragraph 1.1.1, and I
Yes.
asked you to join me in reading it together. It says, on 21 June 2017, the Portfolio Committee on Public Enterprises unanimously resolved to institute an oversight inquiry into allegations of state capture at South African state-owned companies. In doing so, the committee exercised its right to oversee performance and governance within the SOCs, in line with the mandate of Parliament of the Republic of South Africa, as articulated in sections 56 of the Constitution, read together with Rule, and it should be Rule 167, and 227, in bracket 1, in bracket B, in bracket Roman 4 of the National Assembly. The committee has made clear its intention to cover all SOCs during this inquiry. Due to the comparatively larger revenue envelope, capital expenditure program, and share size of Eskom, as well as centrality of the power sector to South Africa's development and economic growth prospects, an urgent response to prima facie evidence of corruption at the utility was identified as a priority. The first phase of the inquiry thus focused on Eskom, with the second and third phases, it should be, set to turn to Transnet and Denel respectively. Can I ask you also to consider footnote 1? Eskom's annual revenues are close to triple of those of Transnet and 6 times those of SAA. The scale of its annual expenditure, with 55.8 billion on capital expenditure and 139.6 billion on operating expenses in 2016/2017 alone, appears to have made the utility particularly vulnerable to corrupt interests, with compounding the urgency of intervening to stop the alleged hemorrhaging of resources from this critical institution. So, Chair, you will see why it becomes important for this commission to deal with questions of allegations of state capture relating to Eskom because of its centrality in the economy and also the sheer scale of its operational budget, capital expenditure, and also procurement activities. It is for that reason that we have decided to prioritize Eskom in the hope that what this committee would do in the course of its investigation will be able to help in the attempt to deal with those allegations and, to the extent necessary, make sure that they do not resurface again. Chair, what we have decided to do is to draw your attention to a number of investigations that have been done before relating to those allegations affecting Eskom. We have decided to do so because we think it appropriate that we should not rerun those investigations. We decided to do so because you as the Commission do not have endless resources in order to rerun investigations and inquiries which have been previously done. We have also decided to take you through these reports in the first instance because they contain a number of findings, some of which are based on credible evidence which has not been disputed by persons implicated in allegations of state capture. So that at the end of the day, the undisputed versions of witnesses who have testified before in previous investigations or inquiries should stand before you as prima facie evidence of weighty importance so as to enable you to make a finding one way or the other. So it is for that reason that we will take you through these reports to show you that there have been properly constituted and properly conducted prior investigations and inquiries, which have led to certain findings. Let me be clear. I'm not suggesting that all of those findings are justifiable simply because they have been made by previous inquisitors. We're merely saying that at this stage, those findings are a first step in order to help you to make sure that you discharge your mandate cost effectively and efficiently.
Well, you may be intending to say, but in case you were not intending to, it's important to make the point, which completes the point that you have just made, that those findings that might appear not to be justifiable on the material or evidence that was before the bodies that were making the investigations will be looked at and to see whether there is evidence that may be found elsewhere to show that they are justified or not justified. So, in other words, to the extent that the reports or some of them might have gaps in terms of findings, then the Commission will be applying its mind to that, and the legal team and the investigators will apply their mind to that with a view to seeing which findings need further investigation to see if they can be backed up, which findings need further investigation to show that there are challenges with them.
Yes.
Yeah. Okay, thank you.
Chair, that's the fundamental basis of the model of investigation your investigators have undertaken. That is a model of presenting evidence that we would follow. And it's a model that we as a legal team have termed as the gap analysis model. And so the gap analysis model will investigate, interrogate two forms of gaps, and I'll get to them in detail later on. But to give you some assurance about how we tend to run the Eskom inquiry in a cost-effective fashion is that the gap analysis model will interrogate two forms of gaps. The first gap would relate to interrogation of those findings previously made by bodies, committees, or persons that conducted investigations into Eskom, but whose findings of fact we still have questions around them because we think that they require further analysis in order to justify them in a manner that we believe can stand the test of time wherever they may be challenged. And so that is the first model of the gap analysis. You look at what has been previously done, You look at the factual findings, you ask yourself, are they enough to resist any form of challenge? If you come to the conclusion that more is required to do, then we will engage in that exercise of reinterrogating the findings by reason of presenting further evidence in order to make sure that by way of some compounded form, they can resist any form of challenge. The second form of gap analysis relates to transactions impacted or affected by suspicious conduct relating to state capture, fraud, corruption, or of other malfeasance of a similar kind, which have not been previously investigated by any other person or body, and which transactions fall within the mandate of the Commission. And to that extent that there exists that type of gap, we, of course, with the assistance of the investigators, have looked at that gap, have sought evidence, and have inquired into whether or not the evidence concerned is sufficient to be presented before you in order to make a finding on those new transactions. And we have found some in respect of Eskom. Obviously, I run ahead of myself, but I can, for the present purposes, tell you that one of those second category of gaps type of transactions relate to something called Huarong, H-U-A-R-O-N-G. It is a transaction which we have not come across in any of the prior investigations, but it's a transaction which, upon investigation, we were quite satisfied that it is impacted by allegations of state capture. We would like to present that new evidence before you so that at the end of the day you make a finding. So those are the two components of the gap analysis model that we will engage upon in detail as we present the evidence before you.
I think that the approach commends itself because on the one hand, it's cost effective in the sense that we don't just we don't rerun processes that have been run by other bodies, but at the same time, it ensures that we don't just accept findings made by other bodies as they are. And the approach requires that we apply our minds very thoroughly to findings made by other bodies and see whether they are defensible, they are justifiable, and if they are, then we can consider accepting them. And if they are not, we don't just reject them, but we look at what other evidence may exist to try and either justify them or show that they should not have been made. Yes. And in the process, the approach is cost effective, and it makes a lot of sense. Chair, so I think it's a good approach.
We're grateful for that, Chair, and we will try and make sure that we stick within the parameters of that approach. But let me be clear, I'm not suggesting that there are no other models. And to the extent that there's a need to depart from that model, then we will be the first to acknowledge it.
Yes, yeah, no, that's fine.
Chair, there is another reason why we commend that model. And it's a reason which I was going to explore later, but I should do it now because it will give you a sense of why, beyond questions of resources, beyond the questions of time, it is vital that this model should be followed in this case. The reason relates to your powers in the rules of the Commission set out in paragraph 3.10. But you don't have.
I've got it here, but I don't need to have a look at it.
No,
you will read it to me.
I will read it out
Yeah.
for you and for my colleagues and any other interested person. Rule 3.10 reads as follows. The chairperson may at any time direct any person against whom allegations are made in a witness statement or evidence to respond in writing to the allegations relating to him or her in that statement or evidence, and or answer in writing specific questions put to him or her by the chairperson arising from the witness statement. We have come to the conclusion that in this round of evidence presentation, time has come that we should persuade you to invoke that power, because the evidence that we're going to present before you, through statements, through transcription of evidence of witnesses who have previously testified elsewhere, together with the evidence which we will present from witnesses that we have consulted with and from whom we have taken statement, a combination of that body of evidence will clearly implicate certain persons. As far as we have been able to scan the history of previous inquiries on Eskom, very few individuals who have been implicated in allegations of state capture have been called upon or have had the initiative to present their own version of evidence relating to what implicates them. We believe that time has come for the Commission to have a balanced view of evidence related to allegations and counter-allegations of state capture. And to the extent that the body of evidence we will present before you implicates those persons, time has come for the Commission to call upon them to respond to those allegations. We will, in due course, identify by name, by number, or other details available to the Commission persons who have been implicated, and in respect of whom we will ask you to invoke that power. That, we believe, is another important reason why the model that we propose to follow is so vital for the Commission in order to get to the bottom of the truth relating to those allegations, Chair.
I don't know at what stage you were planning to ask me to invoke those powers. It may be that you intend to ask me to invoke them right at the beginning of the Eskom hearings, or somewhere during the course of the hearing, or after the hearings have been completed. But it seems to me that to the extent that consideration could be given to me invoking my powers to require such implicated persons as may be identified to put up statements or affidavits to deal with allegations against them that already exist in one form or another, whether it's in a statement or in some report. It may well be that you should give consideration to not waiting until the end, so that the next 2.5, 3 weeks that we have, that could be part of the time that people have to prepare their affidavits, So I just mentioned that as something that may need to be looked into.
Chair, we're grateful for that remark. In response, I can indicate to you that there have been a variety of responses from persons falling in that category. Some of them have chosen to become whistleblowers, and there is an ongoing engagement between them and the Commission. Some have professed cooperation with the Commission. We don't know whether it's feigned or real, but nevertheless, the Commission's investigation are interfacing with those persons. Some have flatly disputed those allegations, and therefore they would clearly be a primary candidate for the invocation of those powers, because as far as their public version is concerned, they resist and they dispute implication on their part in allegations of state corruption. So it is because of this different broad range of responses that there is an ongoing debate in the legal team, and of course the investigators, in order to make sure that we formulate appropriate attitude, so that when we come to you, we are convinced that we would not jeopardize. Instead, we will be promoting the efficient working of the Commission. So it is because of those different responses that I'm not able to give you an answer at this stage.
Okay, no, that's fine.
But we accept that the Commission cannot wait until the end of the Eskom evidence in order to invoke or ask you to invoke those powers.
Yes.
At some point, we will do so.
Yes.
And I can assure you that the present proceedings that we're engaging with at the moment, it's public notice enough to persuade those who think that they can make a contribution rather than to wait for evidence publicly to be revealed of their involvement in state capture, to come forward and cooperate with the Commission. So it is yet for that reason that we're engaged in this public exercise, to give the public and those affected notice that they still have a chance to cooperate with the Commission in order to come clean and clear their breast of these allegations or suspicions to that effect.
No, that's fine.
Chair, so I hope that you're not going to kill us, because I'm afraid today and probably for the better part of tomorrow, you're going to hear us talk instead of the witnesses. But the exercise for today is firstly going to start with the presentation of the reports in order to do that gap analysis.
Yeah.
When we're done, we will take you to the evidence previously presented, at least before the Portfolio Committee.
Yes.
Of part of the National Assembly. And the body of evidence that the Portfolio Committee has received fall into three categories. The first will be written statements made by a number of persons who were willing to testify before the Portfolio Committee. We have a bundle of those statements and we will present them before you. Again, some of the statements we believe that are sufficient enough to constitute prima facie evidence that requires a response. Others, we believe, require further evidence from the same persons or other persons who can corroborate them in order to close the gap. The second body of evidence before the Portfolio Committee was live evidence recorded and ultimately transcribed by persons who testify before it. Often there is an overlap between the statements and the transcription of that live evidence, because most of the persons who testified had previously given statements to the Portfolio Committee. But the transcription are important because they elaborate on a number of questions which members of the Portfolio Committee put to persons. It is important as we go through that, in an attempt to persuade you that Rule 310 power must be invoked, that elements of the transcription indicate at some point, admissions without question of clear contravention of the law and failure to fulfill duties. So as we go along, we will identify those aspects of the transcription. It's a documentation, labor, and intensive exercise, but we'll get to that point. The last category of the evidence presented before the committee.
Well, before that, just for the sake of completeness, it may well be that the rule that you have referred to, it may well be that the powers to be invoked may be the powers provided for in that rule, either read alone or read with Regulation 10.6 of the regulations, obviously because of the various legal aspects relating to the two into which we won't go today.
Yes.
Yeah.
The principle and the statutory wisdom of that rule is reflected in Regulation 10.6. It is also reflected in Section 3 of the Commissions Act. They have different purposes, but the principle is the same. And to the extent that a legal debate arises about the reach, we will engage on that debate with reference to the specific parts of the regulations and the Act. Chair, was outlining the third category of the body of evidence presented before Parliament. And that comprises submissions by interested parties, namely NGOs, that were made to the Portfolio Committee. Again, they're there, we've collected them, and we'll present them before you. They are important because they reflect concerns of civil society on a public-owned entity of vital importance to the country. And we would submit that the Commission must have regard to them because it's a vital stakeholder in relation to what they sought to present before the Portfolio Committee. That then is a body of evidence that we'll present before you. But as against that, in order to close the gap, we will call witnesses that we thought it appropriate to present before you, again, in order to complete that gap analysis. Chair, may I at this stage hand up to you a timetable that we have prepared outlining the presentation of the Eskom evidence from Friday going forward.
Is that the one that Ms. Newman sent to me at some stage last week, or is that another one, or a revised version?
I prefer to hand up the one that I have because it's a final timetable as far as I know.
Okay.
She now whispers to me that there have been some minor changes in relation to the one that you received previously.
Okay. No, that's fine.
Chair, I present this timetable to you in duplicate because I know that you prefer to have one here and one at home, so that when you work your way through the endless evidence presented before you, you don't have to be concerned about what was left at the office or at home, or vice versa.
Thank you very much.
Chair, you'll see that the timetable deals with the week beginning 18.
I can see that there have been additions,
yes.
but a lot of it seems the same, and
yes.
then there have been additions. Yeah, okay, thank you.
And we have now dealt with the 18th and 19th, which is the Treasury witnesses. There is one matter that we would like to draw your attention to by way of a diversion. When we closed the proceedings relating to the Treasury witnesses,
yes,
you made it quite clear that the lawyers of Mr. Van Rooyen must submit an affidavit explaining matters of concern you raised with them both in the letter you directed should be sent to them and in the course of open hearings. We understand and have now been given a copy of a supplementary affidavit that he made, and we would like to draw your attention to that fact so that you are aware that there is that affidavit.
Yes, I was given a copy yesterday by Mr. Norman, and I've actually read it.
Yes.
Yes.
What would remain, Chair, is to make logistical arrangements for the set-down of the hearing of that application.
Yes, no, and I'm grateful that you raised that, because after reading it, I thought that it is necessary to map out the way forward as to what must happen by when. Yes. You will remember that I indicated that it might be necessary for me to deal with it in chambers, and nobody had a problem with that. But what does remain before we get there is whether everyone who is supposed to apply their minds to it has done so, to decide whether there are things to be investigated in the affidavit, and whether there'll be a need to put up any affidavit.
Yes.
The preliminary view I took of it was that it may be necessary to really apply one's mind to it.
Yes.
So maybe for now we should have some date by when one will know whether there is whether there's any further work that anybody wants to do in regard to either responding to it or investigating some of the things said there. Yes. That's for the legal team, but also that's for Mr. Fuzile's lawyers as well.
Yes.
So maybe if we put next week, Wednesday, I wonder whether that wouldn't be enough time for that, or maybe to be generous, Friday.
Chair, we will relay those questions to the lawyers of Mr. Van Rooyen and also the lawyers of Mr. Fuzile.
Yes.
You remember that they indicated to you that they will apply for cross-examination of Mr. Van Rooyen. I don't know where they get that right, but they may be reading the rules different from how we read them.
Well, I see that we haven't had people representing people who are not implicated applying for that leave. So, but we will look at it when it comes.
Yes.
So, so I think maybe let's simply say, if anybody has to file anything, it should be by next Friday. I'm just not sure. I haven't checked the rules. I don't know whether I may be cutting short a period that where people might be entitled to a longer period. I don't know whether on your feet you are able to.
I will ask my colleagues who
to look at that.
Mathematically inclined to.
Otherwise, what we can do is that we can leave it on the basis that you will, the legal team will speak to the lawyers of other parties concerned and indicate that the inclination is to fix next Friday, and let them indicate, and then either tomorrow or on Friday morning, I can then finalize that aspect, and there can be an indication if that time is seen as too short.
Yes, we're grateful for that guidance, Chair, and we'll report back to you about the progress on that score.
Yeah, thank you.
Chair, then the timetable moves on to the 20th, which is today, to tomorrow, which is the question of presenting the reports and evidence. And then we move to Friday, which is the first witness that we would want to present before you. It is the chairperson of the board of Eskom, which was appointed in January 2018, led by Mr. Jabu Mabuza. We have received a statement from him, together with annexures, which is quite useful. We thought it wise to begin with him, Chair, because he leads the board which was appointed on a clear premise that it is, quote, cleanup, close quote, board. So we have written to Eskom identifying specific issues that the board led by him had to deal with, because we thought that a board of that sort, when it comes in to clean up, it must tell you what it found when it got there, what step it took to clean up, and where it is in terms of its cleanup exercise, so that his evidence will thematically answer those questions. And we're grateful that he has done so. There are questions that, of course, we would like to probe arising from the version that he has put up.
Yes.
So we have reserved Friday the 22nd and Monday the 25th for his evidence.
Yes.
And no doubt, we know that you too will have some concerns to raise in relation to his evidence. So we think that the period of 2 days would be enough for that purpose, Chair.
Okay.
And then there is evidence of Mr. Mashego, which deals with Fontaine. Ms. Hofmeyer has worked at length on this question. And you will see when we take you to the Denton's report that Taketa is the owner of the Fontaine mine is not mentioned in that report in relation to the mines that have supplied Eskom. Taketa arises for the first time after the Denton's inquiry, and the Denton's report is vital amongst others for that reason. But the presentation of Eskom's evidence relating to Fontaine will be led by Ms. Hofmeyer. And I have no doubt that before she starts with that evidence, she will give to you an opening introduction about how she plans to do it. We have statement.
Well, I have already seen a memo that she sent to me, which gives me quite a good idea of how she intends to do so.
Yes.
And yeah.
So you would have picked up from that memo that the introduction of Taketa into that mine arose in 2015 and in circumstances that were worrisome. It was given a preferential treatment in relation to due diligence questions that Eskom always undertakes to make sure that a supplier of that kind would meet its contractual requirements. It was given preferential treatment in relation to the pricing relating to the coal it supplied to Eskom. But those are matters of detail which Ms. Hofmeyer will explore with you. And I can also mention that your investigators have come up with emails that show exchange of confidential information relating to Eskom that were disclosed by officials of Eskom to persons who have had interest in Taketa in a manner that is worrisome, and that, in our view, ultimately, when we make submissions, indicate how this project of state capture was implemented in relation to the Fontaine mine post-acquisition by Taketa. And then on the 27th, Chair, we'll get to the first leg of the optimum coal mine acquisition by Taketa and ultimately Opaque. We will present evidence of that first leg of the optimum coal mine acquisition through a representative of Optimum Coal Holdings, ultimately owned by Glencore. He was the chief executive officer at the relevant time of the company which owned the mine. If I don't misspell his name and surname, it is Mr. Clifton Efron. He will present evidence on the 27th. We now have a signed version of his statement. Okay.
Yes.
And in that statement, Chair, he implicates a number of people. Due notices have been sent or will be sent in relation to those persons. And he will give you a perspective, which we believe was not there before, relating to the acquisition of Optimum Coal Mine by Taketa, and the operating pressures that were brought to bear on Optimum Coal Holdings to dispose of that asset. And my reading of that statement, without anticipating his evidence, is that there were at least 3 different kinds of operating pressures that were brought to bear upon Glencore to dispose of that asset. The first was the invocation of the penalty clause in the coal supply agreement that was existing at the time between Eskom and Optimum Coal. The result of which was to suggest an imposition of penalties in the order of 2.1 billion rand on Optimum Coal. As a result of that, Optimum Coal Holdings decided to declare what it is called the hardship clause, because that would have led to the financial ruinous circumstances. And that put, ultimately, the coal mine into business rescue. The second part of his evidence relating to the pressures brought to bear upon that entity to dispose of the mine relates to a failure of what it is called the draft 4th addendum, arising from negotiations between Eskom and Optimum Coal Mine to reach an agreement to resolve questions of penalties that were intended to be imposed, questions of price, and question of quality of coal. The negotiations were thorough and were ultimately supported by the executive committee of Eskom. They failed at the level of board approval and the new CEO who took over at the relevant time. And the result of that failure was that Taketa was facing the potential, Optimum Coal Mine was facing the potential of penalties. The last element of the pressure was the issuance of the so-called Section 54 notices on different mines owned by Glencore in order to bring about pressure for it to dispose of that mine. And that, in sum, will be the operating pressures that Mr. Efron will canvass in the course of his evidence to show how ultimately Glencore, of course, as the ultimate owner of the Optimum Coal Mine, took the commercial decision to dispose of that mine to Taketa. We have set down his evidence for a day, and we hope that we will complete it within a day. And if we don't, of course, we will appeal to him to come back on a date convenient to him and the Commission. And then on the 28th of May, Chair, you'll see that Mr. Manuel will come to testify on 1.1 to 1.3 terms of reference. He will testify on a matter that is now publicly a matter of common knowledge relating to what was said by one member of the NEC of the ANC concerning his appointment to office as a minister. And then on Friday the 1st and Monday the 4th of March, you will hear evidence relating to Huarong. My learned friend, Ms. Norman, will deal with that issue. As I've indicated to you previously, Huarong is a new issue. It reflects a model of state capture, of state-owned resources, which we have not seen before. But I have been asked to convey to you that that model was attempted in relation to resources of South African Airways, and that when Ms. Hofmeyer deals with South African Airways state capture project, at least as far as the allegation goes, you will see the commonality between the Huarong model and also the SA model, of course through different players.
Yes.
So that is going to become important, Chair, because it reflects a totally different model of state capture. As I said, Ms. Norman will lead our team in that regard. And then there will be Mr. Naga and Mr. Opperman, who will testify on the same date. Again, we have received statements and relevant notices have been actioned. There will be Mr. Bester, who will testify on Fontaine again, and his evidence is likely to go to the 7th of March. And from the 7th of March, at least after the completion of Mr. Bester's evidence, we propose to begin with the evidence of McKinsey relating to its contractual relationship with Eskom. I can tell you that we have had meetings with their legal representatives. We have invited them to submit a statement to deal with specific issues that we have raised concerning their contractual involvement with Eskom. And they have undertaken to give us that statement. Of course, the choice is theirs. If they don't give us a statement, as we hope they would, then we will come back to you via Rule 310 to call them to respond to the issues that we have raised. And let me be clear on the score. You would recall that the question of McKinsey's contractual relationship with Eskom and consequences that are arising from that relationship have become a subject matter of ongoing litigation. I believe that Eskom's application to set aside the so-called Master Services Agreement with McKinsey will be heard on the 23rd and the 24th of March or April, I'm not too sure. But we have made it quite clear to McKinsey. Or let me interrupt myself. You would know also that that litigation still continues, despite the fact that McKinsey and Eskom have reached a settlement agreement, in terms whereof McKinsey undertook and ultimately paid the fees it has earned from Eskom as a result of the Master Services Agreement. There is still a question mark, and we have asked McKinsey to deal with that question mark. Whether the payment that it has made back to Eskom relates to the services it has earned from Eskom only with reference to the so-called Master Services Agreement, or a prior agreement which is identified as the Corporate Services Agreement. We have concern in relation to both agreements, and we have raised those concerns with McKinsey, and we hope that they will address them. And we believe that despite the settlement that they have reached, we as a commission, and you as the chairperson, are entitled to interrogate allegations of state capture on those two transactions to see whether or not they are not affected or are infected by some possible wrongdoing which include commission of an offense or some other impropriety. We ask you to do so despite the settlement agreement because both the Funduzi report that we will refer to on Eskom, as well as the report of the National Assembly's Portfolio Committee have recommended that criminal investigations should be undertaken relating to a number of persons who are involved in, amongst others, those transactions. So it is for that reason that we would ask you, Chair, to consider the question of McKinsey. Of course, it will affect its BE partner, which we now know from the evidence we've gathered. The relationship between it and the BE partner had terminated sometime in, is it March or April? March 2016. And it's a question of whether McKinsey has had a BE relation with an entity called Trillion Management Consulting Management Company, or Trillion Capital. The number of trillions, the evidence will indicate where each of them falls. Chair, you have before you the affidavit made by one of the whistleblowers, which we presented before you when Mr. Fuzile testified. I did not mention the name because I wanted to keep the name confidential, and I'm not going to reveal it. But that affidavit is before you, and it explains how this relationship between McKinsey and Trillion had some problems, which raises enough basis to investigate whether or not there were no conduct.
Yes.
Chair, that will take us to the 8th of May. And then on the 11th of, sorry, the 11th.
Well, we must immediately rearrange because the 8th of May will be a public holiday.
Sorry, I said the 8th of May instead of the 8th of March. My apologies.
Oh, okay, 8th of March.
Yes.
Oh, okay.
My apologies. 8th of March.
But for what it's worth, we should look ahead in regard to 8th of May and make arrangements, reschedule if we have already put in something.
Yes.
Okay.
The Transnet team who would hopefully be the date.
Of that, yeah. Okay.
And then, Chair, we then get to the 11th of March. On that day, we propose to present evidence of two individuals. The one representing Standard Bank, and it's a witness that you have heard before, but in a different context. It is Mr. Ian Senton. I believe that he's present here, and he gave us a copy of his affidavit on the strength of which he's going to testify. His evidence, Chair, will reveal something that we believe has not been investigated before by others who had become engaged with allegations of state capture relating to Eskom. And that is the movements of funds from some of the entities in accounts, and Standard Bank raised concerns around those accounts and the way money and balances were moving in those accounts. And Standard Bank called for explanations. And the explanation, for that reason, Standard Bank decided to fulfill its banking regulatory obligations by filing what they call STR, which is the Suspicious Transaction Report, with the Financial Intelligence Center. And accounts. The evidence of Standard Bank becomes important as a vital piece of proving state capture on how money was laundered from state-owned entities and moved to different components of account holders who had nothing to do with the services purportedly provided by contractual partners of Eskom and or Transnet. Mr. Senton will testify on that score. And we will look at the draft statement he has given us today with a view to action it in terms of the rules. And then we'll get to the evidence of Mr. P.S. Marsden, who is a co-business rescue practitioner in charge of Optimum Coal Mine Holdings, Pty Limited, when it was still under business rescue. He will give you an additional perspective of the evidence he has in relation to the acquisition of that mine by Taketa and the report that he filed in terms of Section 34 of the Corruption Act relating to knowledge he gained about something that he thought raises suspicions of corruption in relation to that transaction. He has given an additional statement, and we obviously have looked at it, and to the extent that it implicates people, the rules. And Chair, there will be the 13th and 14th, which we have planned in case there is a need for you to hear additional evidence.
Yes.
The 13th relates to the evidence of a cyber specialist. We have been drawn to his attention and the work he has done by lawyers of Eskom. And the evidence of that cyber specialist, as far as we have seen elements of it, whether aspects of the Funduzi report relating to the exchange of email by persons who were the executives at the time of Eskom, firstly as between themselves, and secondly as between themselves and third parties who had some interest in Eskom. That evidence is well-founded or not. And secondly, that cyber specialist will tell you about how he went about procuring the emails from the central server of Eskom, who had no legitimate basis to receive confidential information from Eskom. When I take you through the Funduzi report, you will see how the email evolves, and you will see how the evidence of that cyber specialist would become important in order to provide sound evidence in relation to state capture project. Chair, may I say even here that the lawyers of Eskom have drawn attention to two disciplinary processes which Eskom initiated in earnest against some of its executives. And some of those emails which it received through this cyber specialist were put to these executives in order to call for them to explain. None was forthcoming, and the little that, if ever, came forward as explanation was not enough. And so the evidence of the disciplinary process indicate and deal with some of those disciplinary steps taken. And we'll ask him on the outcome of the disciplinary processes and the body of evidence that Eskom introduced. And on the 14th, we would propose to lead evidence of two whistleblowers. The one, as I said, you have the statement before. The other, you will see her evidence as we present the transcription and the statements made in or before the portfolio committee. That, Chair, is the body of the evidence that we would present to you in what remains of this month and the first part of next month.
No, thank you very much. Yes.
Chair, again, I apologize that you have to listen to me for most of the day.
Yes, no.
We we are now going into the next phase, and that is to present various reports to you. I wonder whether this is not an appropriate time to adjourn for tea.
I think it is. We will take the tea adjournment and we'll resume at 11:30. We adjourn.
All right.
Yes, Mr. Maleka.
Chair, in the next round of the presentation, we are going to deal with the reports via a document we have prepared called the gap analysis on Eskom. I believe that a copy of the document has been presented to you.
Yes, I've got it.
I will ask Mr. Jakswart to present and illuminate some of those slides on the monitors so that those concerned may see precisely what our analysis in terms of the slides is. And so, Chair, as I say, the analysis begins with the presentation of the reports to you. And we are grateful to our learned friends, Ms. Norman and Mr. Mokoena, because they are the ones who took the effort of asking the investigators to source and produce and also compile these reports in a format and form that is readily accessible. And I understand, Chair, that the files before you have been marked on the spine through volumes for easy identification, and that in due course, your files will be marked with a clear descriptive indicator on the spine, precisely what the contents are.
Yes, that will be very helpful.
I have been assured by Ms. Norman that by resumption of the proceedings after lunch today, they will be in the form that you had indicated.
That's fine, that's fine.
So, Chair, just before I start with the gap analysis in terms of the slides, I'd like to take you to a report which is in volume 6.
Yes.
If the first page of volume 6, you will see it's again an index. And file number 16 is the report on an inquiry conducted by the National Energy Regulator of South Africa, NERSA, relating to the load shedding and electricity supply shortage, which occurred on the 12th of May 2008. We take you to this report as a starting point, not only because of what NERSA did, but the repeat of what is happening in relation to Eskom regarding load shedding activities. This report records for the first time, as far as we are aware, and we confess our knowledge may be limited, that a regulator in our country decided to conduct a statutory inquiry in terms of Section 4(2)(b) of the Electricity Regulation Act relating to the activities of a licensee, such as Eskom, relating to questions of load shedding that had fundamental consequences for the country and which raised serious national concerns. We are not aware of any other inquiry which NERSA may have undertaken arising from the repeat of the difficult experiences suffered by Eskom in terms of the supply of electricity. We take you to this report for now, Chair, because when the chairperson of Eskom testifies, we will raise issues around questions of load shedding, and hopefully he will indicate to you how Eskom is busy dealing with those difficult questions. But the key question which we would really ask you to consider for the purposes of the Commission is, what are the other options consumers such as you and I have when these things happen? Or is it a normal consequence that we have to live with as consumers in the face of the powers conferred upon the regulator to consider those aspects? So, Chair, when you will see that the report begins at page 1976, and there is a table of contents on 1977. I ask you to go to the introductory portion of the report at page 1978. And I ask you to read with me the second paragraph from the top. In the light of the above, the energy regulator decided that an inquiry be conducted in terms of section 4 in bracket B, Roman 2, and 4 in bracket B, Roman 4. I can ask you to strike out that section because I've looked at the Electricity Regulation Act. There is no section of that sort in that act.
Is that the Roman figure that is not there, or the whole?
The Roman figure 4. As far as I'm aware, the latest version of that act ends with Roman figure 3.
Okay, and it wasn't there and has since been repealed in
No,
98 or something.
I've also looked at the previous versions of the amendment. I could not find it, but I confess that, in these sorts of things, one is wrong. I can assure you the latest version does not have Roman figure 4.
As for the sake of completeness, if you haven't had enough time, somebody can just check whether as at 2008,
yes,
it wasn't there.
Yes. Into the National Electricity, Roman figure 2 of the Electricity Regulation Act, 4 of 2006, into the National Electricity Supply Shortage, and the subsequent load shedding by Eskom and other licensees during the period 1 November 2007 to 31 January 2008. I ask you to note that the relevant period covered by NERSA's investigation was for more or less a period of a month or slightly more. But it is for that period that NERSA decided that it was going to engage into load shedding because of the consequences of it. And then, Chair, you will see that in...
Isn't that 2 months, November to 31 January?
Yeah, it's about...
Or actually
well, 3 months.
3 months.
3 months, effectively, yes. You're correct, it's 3 months. The purpose of this inquiry is to inform the energy regulator of the reasons for the current electricity supply shortage, resulting in the national load shedding of the electricity, and recommended measures to be adopted to mitigate against the electricity supply shortage and to reduce the adverse impacts thereof. The scope of the inquiry focuses specifically on events in the period 1 November 2007 to 31 November 2008. And yes, my notes indicate that that is a period of 3 months.
31 January, I think you said November.
1 November 2007 to 31 January 2008. And that's the period of...
Yeah.
Paragraph 2 talks about the methodology of the investigation. I'm not going to ask you to consider it.
Yeah.
Paragraph 3 gives you some background about Eskom, and it's a background that I will develop when I ask you to consider the Denton reports. But at that stage, it was quite clear, according to NERSA, the regulator, that Eskom was controlling 92% of the generation of electricity in our country. And then, Chair, the next part of the report, which is important, is at page 1981, paragraph 4. Load shedding was experienced during the months of November 2007 to January 2008. The high number of load shedding incidents in January attracted national attention. There were 5 load shedding incidents in November and 4 in December, arising mainly out of generation capacity shortages. In January, 14 incidents occurred due to both energy and capacity constraints. The high frequency of load shedding in January was related to the increasing demand, about 3,000 megawatts, after the December holiday period, and an increase in the unplanned outage rate as shown in figure 1. And then, Chair, I'll skip the rest and ask you to go to paragraph 5.
Yes.
Measures of an adequate and secure power supply is the ability to continuously balance supply of power, that is generation, and demand for power, load. The balance is maintained by controlling the frequency to 50 Hz. If demand exceeds generation, the system slows down, and the Eskom National Control Center instructs power stations to increase generation from available plant. Where there is no more available plant, the system will slow down and eventually collapse unless the load is reduced. So that gives you some kind of a non-technical explanation around how load shedding happens. Even I, as a non-engineer, am able to follow the relationship between the demand for electricity and the supply of it, and how ultimately, if there is an imbalance between the two, the system, if not properly managed, would give rise to the national collapse and a national blackout. And Chair, I ask you to go to page 1982, just before the figure 1. There is a paragraph which gives you the indication of what was the extent of load shedding. It's the second unnumbered paragraph.
Yes.
The November and December incidents were mainly caused by inadequate generating capacity, resulting mainly from generator trips. The more severe load shedding incident of up to 4,000 megawatt occurred on numerous occasions, 17 days in January, as a result of both capacity and energy shortages. The extent of the capacity and energy constraints and the applicable reasons are discussed later in the report. Then they give them to you, Chair, in that figure, beginning from 13 November, cutting across through the y-axis up to...
yes, that's figure 1 with...
the bar charts.
Yeah,
Yes. And you'll see that the bar charts are, again, in all these diagrammatic expressions of the horizontal line and the vertical line, which you were told that the one represents the x-axis, the other represents the y-axis. The horizontal line gives you the degree of load shedding from the date 13 November 2007. It goes across to January 31, 2009. And then as you look at the vertical line, you will see the amount of megawatts of electricity that were shared during each month.
Yes.
And you will see that the peak of
I see that the last vertical line relates to 31 January 2009,
Yes.
and the one immediately before that is 30 January 2008,
It should be 30 January 2008.
the last one.
Yes, because that's a period of investigation conducted by NERSA.
Yes,
So
I
you're
thought
quite
so too.
correct. I think
Yeah.
it's 2008.
Yeah. Thank you.
And Chair, for the purposes of completing our attention to this figure, we merely point out that the peak period of shedding of 4,000 megawatts of electricity occurred on 24th January 2008. That's where you find 4,000 megawatts of electricity shed on one day. The rest is a variation from 1,000 up to 3,000. But we would ask you to note that the worst form of load shedding occurred on 24th January 2008. And
I
this
think
one,
I can see that in terms of those vertical bars, that is correct, but I thought you said 4,000. It appears to me to be close to 7,000. Do I misunderstand something in this?
No, I think the load shedding, if you look at it, is in darkness. It's a dark,
okay,
the darkest
okay.
shaded, because if you look at the legend
Yes,
at the top,
yes,
just below the heading, correlation between load shedding and unplanned outages.
yes, okay.
The darker one
okay.
is load loss.
Yes, okay. Okay, so it was just under 4,000.
Indeed.
Yeah,
Well, the
okay.
report suggests that it's 4,000.
Or maybe it is 4,000. Well, the red line goes up to 4,000. The
Yes.
darker line is just below
Yes.
the line for 4,000.
Yes.
Okay.
And Chair, the next is, once you have the appreciation of what NERSA's investigation reveals, the next important question which NERSA had to engage with is at page 1985.
Yes.
At the top, the economic impact of load shedding events is not readily available. However, for generation capacity planning purposes, the cost of not supplying electricity is deemed to be 75 rand per kilowatts of electricity. This implies that the load shedding in the period cost the South African economy approximately 50 billion rand. That is NERSA's estimation without reference to scientific research, but simply an indication of what happened or what happens when the country suffers consequences of load shedding and the cost to the economy. We would like to develop that issue later on, as soon as we get to the issues relating to Eskom. And hopefully those who have information will help us in that regard. Chair, I leave the rest and go to the findings and recommendations.
Yes.
And that you will find at,
Well, there is a reference to recommendations on the same page, but I don't know if that.
no, it's not that one. It's at page 2015. I'm not going to read them out to you. I merely want you to note where they are to be found.
Yes.
And then the recommendations follow at page 2017. And the sum total of it was a request by NERSA that Eskom should do certain things to prioritize corrective measures so as to avoid these consequences. And some of them were directed at specific departments of Eskom, like primary energy. For instance, if you go to page 2017, the further investigation and the recommendation reads as follows: primary energy procurement and management, and in particular, coal management in Eskom, the availability, adequacy, and optimum utilization of Eskom's generation plant in emergency and in view of the midlife of these plants. These are critical areas of operation that affect Eskom, which the regulator recommended that they should be looked at in order to take corrective measures. We will get to the Denton's report because it comes almost 7 years after this recommendation by NESA, and it raises numbers of questions relating to the operations of Eskom. And it makes findings at the request of Eskom and present them before Eskom with a view to take corrective action. What follows thereafter is no longer the implementation of the observations made by Denton, but something else. And it's that something else which we submit begins to provide clear indication of the state capture project. So that's why we started here, that this report is important in sequence in order to show you that questions of load shedding were not new as and when they repeated themselves in 2015, and as and when they still occur this year. They've always been on Eskom's radar. NESA is a regulator. It inquired into the reasons, it got the reasons, and NESA made recommendations. And yet the problems still occur.
Well, one will hear all the evidence and look at all the reports, but it certainly is a matter of concern that when load shedding happened in 2008, my recollection is that the executive admitted that it had been warned about, if I recall correctly, 8 years earlier.
Yes.
By the management at Eskom, that if certain things were not done, that is what was going to happen. And from my recollection, there was an admission that not much was done, and load shedding happened.
Yes.
And then it's more worrying that notwithstanding that lesson, it happened again. It was in 2015, and it's happening again in 2019, and with even more intensity and seriousness. So, yeah, okay.
Chair, if it's necessary, we will consider that issue and seek to present clear, undisputed evidence about what happened when that warning came to the fore and what happened thereafter. But anecdotally, you're correct. There was a clear warning given to the executive authorities of our country at the time that they should not luxuriate in the surplus capacity that they found in Eskom when they took office. Because let's be clear, Eskom has always had capacity which was surplus to its requirement. And it was for that reason that it extended all sorts of benefits to the major consumers of electricity, such as the mining industry, to procure electricity at subsidized rates. I hope they don't kill me. But it was at that level. But things changed when our country, after democracy, decided to put Eskom where it ought to have been by making sure that each and every household is electrified at reasonable costs. It is at that point in time when the strategic shift of Eskom occurred that what was surplus capacity became capacity constraints. And at that point, the executive was warned and nothing was done. So, Chair, to now get back to the gap analysis, may I ask you to go to page 2 of the slides?
Well, we will we'll look at the Denton's report, and we'll hear the witnesses. One hopes that people who were supposed to be taking measures in line with the recommendations of the NESA report and the Denton report were not doing other things when they were supposed to be doing that.
Yes. Chair, I'm tempted to go to the Denton's report in order to address your concern, but I'm not too sure whether I should do it now or leave it later.
I'm happy that you do it later.
Okay.
Yeah.
Okay. Should do it now.
Or is Mr. Mkwena tempting you?
Yes. Can I ask you to go to volume 2?
Yes, thank you. Yes, I am there.
Chair,
Oh, I see Mr. Mkwena tempted you successfully.
I hope it's not a poison pass from him.
Yes.
Chair, you will see that on page 356
Yes.
is the report by Denton dated 2 July 2015.
Yes.
The date is important, and I will ask you to mark it. Mr. So that there is no doubt that this investigation was commissioned by the highest decision-making body in Eskom, and that is the board. 1.2, the investigation commenced on 20 April 2015. A draft report was required to have been provided on 20 July 2015, with the final report to follow 31 July 2015. May I stop here and make the following observations? you will see that the timelines in terms of the board's expectation was that the investigation should immediately commence, and it should produce a draft report on 20 July. And the final report should be presented 31 July 2015. What you have and what we have managed to obtain, and what we would like to confirm with Eskom, is why don't we have the final report? At best, we have the draft report. What happened to this mandate of Denton? And that's a key feature, because as a state body, having obligations of accountability, you follow through the decisions you make, especially when they are directed to inquire into your state of good or ill health. But here, we don't have the final report in line with that inquiry. So we would like to know what happened to it. And Chair, I am at 1.3. On 11 June 2015.
Well, apart from Eskom, shouldn't the authors possibly have it, or have they got some ground of not disclosing it, such as privilege or what? Or is that something we haven't looked at yet?
We will ask Eskom because it is the holder of the privilege. It can waive it. But I can tell you that we tried the best we could when we interfaced with Eskom to see whether or not they can ask Denton to waive privilege. But from the sum total of what we received and what we were able to get is that there has never been anything beyond this draft executive report. So that's the first question we will raise, and I'm sure Eskom.
Well, to the extent that Eskom is not able to give us the final report, or doesn't have it, or doesn't have a satisfactory explanation about why there wasn't or there isn't such a report, I guess that an approach ought to be made directly to Denton's to find out whether a final report was produced by them and whether they do have a copy, and if they say they do have, and see whether they can make it available, or whether they have some ground on the basis of which they might claim that they should not make it available.
Yes.
Yeah.
Chair, the next paragraphs of the report that I will read out to you answer that question.
Oh, okay.
Yes.
Yeah.
1.3, on 11 June 2015, we were requested to prepare a detailed presentation to the board, in addition to a draft report dealing with the state of the investigation to date. We understand that this was due to the need to meet the deadlines for various other commitments that had been made by the board in respect of the timeframes of the investigation. A detailed presentation to the board was delivered on 26 June 2015, which was followed by our draft preliminary report. For these purposes, investigatory activities ceased shortly after 11 June 2015, and resources were directed from the normal course of investigation to the development of a preliminary findings, preparation of the above-mentioned presentation, and preparation of a draft report. 1.4, subsequent to our presentation to the board, we were advised that, 1, the board was satisfied with the investigation and the degree of detail covered in a very short period of time. 2, the investigation had provided the board with the information it needed to take decisions as to how best to manage the affairs of Eskom. And 3, no further investigatory activities were required. So, Chair, the deadlines which the board itself has set out, requiring the finalization of a report into this investigation, was cut short because there was a presentation to the board. And on the basis of that presentation, the board said, Denton, don't even have to finalize. But it is in the context where Denton tells them that we had not yet completed our investigation. We are going to stop our investigation because you are telling us that you require a presentation and you require some draft report. And Chair, 1.5, a draft preliminary report was submitted to the board on 3 July 2015. This was followed by an executive summary on 6 July 2015. A presentation was made to the Minister of Public Enterprises on 9 July 2015. We were then requested to prepare this report as our last submission. This report represents a snapshot of the investigation at the midpoint of the investigation period, about 18 June 2015, and is provided to Eskom on the specific request of Eskom. The findings, views, conclusions, and recommendations set out in this report are accordingly: 1, subject to verification and testing; 2, provided to Eskom as a record of the investigation as at the midpoint of the investigation period; and 3, do not constitute definite findings, views, conclusions, and recommendations. It's a normal disclaimer you have from investigators who had not yet completed their investigation for the obvious reasons. So, Chair, this report becomes vital as a starting point of our investigation into Eskom, because it was authorized by the board, but the investigation was not completed. And the investigators, being Denton, told them that they had stopped at the midpoint of the investigation, and the views expressed herein should not be regarded as definitive from them. So, Chair, that's where we are, and I'm sure questions will arise about why this report was not completed. And you will see that the importance of what Denton records in this introduction is that there were presentations made to all relevant stakeholders of Eskom in terms of decision-making, the board and the minister at the time. Chair, I'm going to quickly take you through some of the key issues of the Denton's report. And some of them you've raised with us, and we thought that we should give you an indication of how they have been answered by an investigator such as Denton.
Yes, before you do that, isn't there something strange that on the first page, that is 0356 of the report, right, the one where you said I must note the date?
Yes.
The date of the report seems to be 2 July 2015.
Yes.
But just immediately below it, so it relates to investigation as at 18 June, the previous month.
Yes.
18 June.
Yes.
But it's finalized on the 2nd of July.
Indeed.
Okay.
So
no,
the
no,
midpoint
that's
of the
fine.
investigation when Denton stopped was the 18th of June.
Yeah,
Yes.
yeah. Okay, no, that's fine.
But the report was subsequently provided
Yes.
almost 2 weeks later.
Yeah,
Yeah.
yeah. Okay.
Yes. Chair, in paragraph 2, on page 370, Denton gives you an appreciation of where Eskom stands as a supplier of electricity. In 2.1, it says the following: Eskom is South Africa's major electricity supplier and is wholly owned by the South African government. Eskom generates about 95% of electricity used in South Africa and about 40% of electricity consumed on the African continent. So you will see that from 2008, the extent of electricity generated by Eskom had increased from 92% as recorded by NESA to 95% as recorded by Denton's in June 2015. Of importance, Chair, is that Eskom generates electricity for consumption not only locally, but also trans-jurisdictionally to other parts of the country. Eskom transmits and distributes electricity to its industrial, mining, commercial, agricultural, and residential customers. Eskom also supplies electricity to municipalities, who in turn distributes electricity to end users within their designated areas. There is a concern, and I'm sure the chairperson of the board, when he testifies, will deal with it, about the extent of recoveries that Eskom suffers as a result of failure by some municipalities to pay their bills to it. 2.2, Eskom owns and operates 27 power stations in South Africa with a total nominal capacity of approximately 41,995 megawatts. Eskom's generating capacity comprises around 35,726 megawatts from coal-fired power stations, 1.860 from nuclear power, that would be Kubek in the Western Cape, 2,409 megawatts from gas-fired power stations fueled by diesel, and 2,000 megawatts from hydro and pumped storage station, as well as 3 megawatts from a wind farm at Kliphevel. I suppose that the hydropower pump storage would reflect to Eskom's capacity in stations such as the Ingula hydropower stations. And then says Eskom's generation fleet is currently divided into 5 operational units: coal 1, coal 2, coal 3, nuclear, and picking, each comprising of the following stations. A, those which are mentioned there: Kendal, Kunsile, Majuba, Matimba, and Midupi. B, on page 371, Duva, it's a name that you'll hear a lot. Kriel, Letabo, Matla, Tutuka power stations. C, coal 3, Arnott, you will also hear a lot about that. Camden, Grootvlei, Hendrina, you'll also hear a lot about Hendrina, and Komati power stations. D, nuclear, Kubek power stations. I don't think much turns on Kubek in this inquiry. You heard a lot about attempts to increase the nuclear capacity. Chair, 2.3, it's another issue which has arisen in the context of the public debates that are taking place in our country relating to so-called IPPs. Eskom purchases electricity from IPPs as well as from electricity generating facilities beyond the country's borders. The company also maintains more than 360 kilometers of power lines and substations with a cumulative capacity over 230,000 MVA. I'm told that MVA is the cables, these high velocity cables that transmit electricity from one point to the other across the length and breadth of our country. 2.5, Eskom has embarked on a capital expansion program and is currently constructing new power stations and major power lines to meet South Africa's growing energy demand. Raises questions around Kusile and Midupi. And so, Chair, those are the statistical data relating to the assets of Eskom, relating to its capacity to generate electricity, And we have given them to you via the Denton's report because we wanted to understand what this animal called Eskom is. We would respectfully suggest that this report gives a very good indicator of what Eskom is all about and what how it goes about in seeking to fulfill its mandate to provide electricity to consumers at reasonable or affordable costs. Chair, unless you want me to take you through the rest, I'm going to skip the rest of the technical data and take you to page 410. And again, I do so not to read it, but simply to note paragraph 2.3.
I'm sorry.
Page 401, sorry, 401, my apologies.
Okay.
And I ask you to consider 2.3 because it's a primary issue that Denton had to consider in relation to the costs relating to the generation of electricity by Eskom. And in 2.3, Denton noted the following. Overall, Eskom has, over the past few years, seen a significant increase in its primary energy costs. And a key question is whether these increased costs are due to prevailing market forces, contractual arrangements, and whether or not these costs are commercially supportable. Again, that begins to take you to questions that we have sought to interrogate with reference to the Fontaine issue and with reference to the optimum coal mine issue in order to see whether or not the increases in costs suffered by Eskom in that regard were supportable on a commercial basis, or there were other reasons which explained the increases in costs. Chair, I'm going to skip the rest. These are matters of technical nature, but I'd like to take you to paragraph 5, which deals with the cost indicators relating to the procurement of coal by Eskom. It's at page 409.
Yes.
It says, a table, I'm reading at paragraph 5.1. Table 1 below provides the current coal prices for each of the coal supply contracts. Cost plus, fixed price, and medium-term contracts, and the power stations to which the coal was supplied. The prices under the long-term fixed price and cost plus contracts vary from 135 to 686 per ton. The average price of coal for the long-term cost plus contracts is 285 rand per ton, including transport costs. All cost plus agreement deliveries are by the conveyor. Chair, I would ask you to note this, because that element of the costs relating to the delivery of coal, for some reason, has fundamentally shifted and now borne by Eskom, insofar as the investigators that have been conducted reveal. Let me be clear. There may be a good reason why a mine such as Fontaine may shift the cost of transportation to Eskom. If there are good reasons, we would like to hear them. But if they're not, well, there has to be an explanation. The average price of coal from long-term fixed price contracts is 250 Rand per ton, including transport costs. Only Majuba Power Station incurs transport costs. The average price across all long-term contracts is 270 Rand per ton. That's the data given to you by Denton at the time, indicating how the price components in relation to the supply of a primary input of Eskom's production, and that is coal and transport, is calculated. Chair, I'd like to give you some evidence of something that I said earlier about Taketa in relation to Fontaine, in relation to the contracts which Eskom had as at 2015 June, when Denton engaged in this exercise. You will see that evidence beginning at page 411.
Yes.
And there Eskom gives you, Denton gives you detailed information relating to the suppliers of coal to Eskom by name. You will see the names of the suppliers in the second column from the left. It starts with Anglo Coal Pty Limited, and it tells you in the next column the power station to which the coal was supplied, and the column thereafter tells you the date when the coal supply agreement started, and thereafter you'll see the CSA end date, which is the date when that long-term supply agreement would have come to an end. And then it gives you the volumes of metrics per ton of the coal which was going to be supplied. And the next one is what they call CV, which is the calorific value of the coal supplied, and I'm told by Ms. Hofmeyer that that relates to the burning capacity or quality of the coal, so that as you burn it more, it produces electricity, but as you burn it less, it produces less electricity. I'm told that I hope that I'm not representing her expertise in that regard.
Well, she seems to nod, so.
Yes. And calorific value is important in the calculation of the price, Chair. You'll get the prices in the next one, which is rand per ton. And you'll see that the lowest point of rand per ton is 135, and the highest point is 686. And the highest point, Chair, you will find with reference to Exaro, which was supplying, amongst others, to Arnold.
Somewhere in the middle.
Somewhere in the first top third.
First third, yeah.
Yeah, first third, the top third.
Yes. I've seen it.
Yes, and again, some of the documentation that we'll present to you, which was before Parliament, includes the representation by Exaro explaining all of these things, because the Exaro supply to Arnold were terminated on the basis that they were supplying at an expensive price. So what you will see from this is that as at the date that Denton compiled this report, there was no reference to Taketa as the supplier of coal to Eskom. And Taketa got...
And this is June 2, or July 2, 2015.
Yes, Chair.
Yeah.
When Fontaine and Optimum Coal are going to be explored, it will be in the context of this historical data sets and data points in order to give an appreciation of what was the price of coal and what changed thereafter. Chair, the last part of this report, without going into the scientific elements of it, relates to the recommendations that were made, and you'll find them at page 425.
Yes.
10.1, it is recommended that the following issues be revisited to secure better prices for coal. Point 1, conduct the necessary feasibility assessment to determine if the long-term cost-plus collieries can be refurbished or expanded to increase production to contracted levels or even higher. So there, Eskom was told that in order to make sure that there are better prices to secure, in order to ensure security of supply for coal, it's important that you should invest in the cost-plus mine, because once you do so, you will have an assurance of better prices and security of supply. It's a key recommendation. Point 2, develop a transparent and a structured framework for credible BEE participation in the primary energy supplies. I emphasize credible BEE participation, because it is through that narrative of BEE participation where all manner of problematic conduct was undertaken, which we would submit ultimately when we make submissions, reflect how the narrative of BEE was captured in order to bring about those ill consequences. But Denton said, whatever you do in relation to BEE must be structured and must be transparent and should lead to credible participation by people such as me and you in the primary energy supply for Eskom. And then 1.3, investigate how long-term cost-plus agreements can be restructured in order to improve BEE ratings where it is required, and investing in these mines, if feasible, to increase production, which will have large impact on reducing the transport costs significantly. 4, changing the approach on securing medium-term and short-term contracts to a competitive tender basis, or conduct a pre-qualification process to qualify for supplies. Point 5, conduct competitive tender for the coal logistics, especially coal transported by road. And Chair, the rest is there. The one that I would like to draw attention is 10.2.1, because it's important for Fontaine. For future supplies, a more rigorous supplier due diligence procedure should be put in place. And you'll hear a lot about how the process of due diligence in relation to Fontaine through Taketa unfolded. 10.2.2, direct purchases from the Chevron refinery in Cape Town should be revisited, and a way to secure more reliable long-term supply should be found. That relates to diesel, Chair. 10.2.3, competitive tenders for the diesel logistics should be conducted, especially for the diesel transported by road. So those were the recommendations, Chair. The rest of the report deals with financial challenges that Eskom faced and what were the financial recommendations that have been made. I'm not going to deal with them. And really, we would submit that what is key and what is before you is how state capture project unfolded in Eskom, and the primary way in which it unfolded and was executed was through procurement. So these are procurement issues and recommendations recorded by Denton, placed before the board, which required to be investigated and implemented if the recommendations were sound. And so, Chair, that's the Denton report. I have taken you to it ahead of the slide presentation on the gap analysis, because it was a matter that you felt strong about. And I would like now to go back to the slide presentation and begin with the gap analysis. Start at page 4. And the first report we reflect, Chair, on page 4 is the Public Protector's report.
Yes.
The genesis of this commission. This report has already served before you as Exhibit A1, as I recall when it was presented to you in the beginning by Ms. Norman. You will see that the slide refers to parts of the terms of reference that are relevant to this commission, and they're identified right at the bottom left-hand corner. You will see that they begin with 1.1, 1.2, 1.3, 1.5, skip 1.6, 1.7, and they go to 1.9. For the present purposes, Chair, we would like you to highlight only 1.4 and 1.5. It is there, it's on page 4. Yes.
Thank you.
Chair, can I please ask you, insofar as the Eskom's evidence is concerned, to highlight 1.4 and 1.5, because those are the terms of reference that are relevant to the evidence which will unfold.
Yes, I found it 1.4 and 1.5.
Yes.
Yeah.
And page 5 tells you how the investigation started. I'm going to skip it because we have dealt with it for quite some time. And page 6 also deals with the key findings which were made by the public protector flowing from the investigation she had done. There are about 16 that we have identified for you, Chair, beginning from page 6 to page 8. I'm not going to repeat them. But the gap analysis in earnest on the public protector's report begin from page 9.
Yes.
You will see the question posed was, can the report or the evidence be placed before or accepted by the DCJ? The answer is unequivocally yes. And then we begin to underline the outstanding issues or gaps or procedures. The first is investigate a possible dispute between a private company co-owned by the President's friends and his own son. I think you know which company that relates to. Is the Taketa and Opaque entities. And you will know that the shareholders of Opaque include an entity called Benguela, owned in large measure by the son of the former president. And then 2, interview Minister Zwane in order to obtain his version of events. Chair, I'm going to stop here and ask you to go to volume 1.
Yes.
In order to illustrate why we think that that gap we have identified flowing from the public protector's report becomes important, and why you as the Commission should interrogate that gap. In volume 1, you will see that on page 309,
Yes.
the public protector deals with Minister Zwane at the time in paragraph O. She says, Minister Zwane needs to be interviewed in order for his version of events to be obtained. It cannot be disputed that Minister Zwane indeed traveled to Zurich, Switzerland, for negotiation between Glencore and Taketa. Furthermore, the minister did not complete his travel itinerary and mysteriously ended up in Dubai, without boarding his scheduled flights from Zurich to Dubai, from Dubai to Delhi, and from Delhi to Dubai. Furthermore, it appears that an additional flight was booked from Dubai to Johannesburg. This amounted to expenditure being incurred to the amount of 96,630 rand. If not contradicted or fully explained, it appears to be an indication of fruitless and wasteful expenditure. Furthermore, it appears as though Minister Zwane acted in personal interest whilst on this trip, and as such, it appears as though his conduct is not in line with Section 2 of the Members' Executive Ethics Act. P, if Minister Zwane traveled in his official capacity to support Taketa's bid to buy the mines, in his conduct would give Taketa an unfair advantage over other interested buyers. Further, it is potentially unlawful for the minister to use his official position of authority to unfairly and unduly influence a contract for a friend or, in his instance, his boss, '(s), son, at the expense of the state. This scenario would be further complicated if his actions were sanctioned by the president. This scenario will be investigated further in the next phase of the investigation. So there is the gap that the public protector left for you to consider and fill, Chair. So we would respectfully suggest that that part of the gap is something that the Commission cannot avoid and the Commission must investigate. In fairness, Minister Zwane must be given an opportunity to give his version of the events. As part and parcel of completing that gap, we will call the evidence of Mr. Clifton Efron, as we have indicated to you, on the 27th of February, to begin to fill the gap in relation to that part of the inquiry. And we have obtained his statement, and he will tell us what happened in relation to this trip in Zurich. And of course, we would not accept his version for the sake of it. We will probe it to see whether or not it is in line with the probabilities of commercial engagement of this kind. So that's the one part of the public protector where we ask you to fill the gaps.
Yes.
And Chair, that takes me to paragraph 3 on page 9. Paragraph 4, investigate the conduct of the Bank of Baroda in relation to the purchase of all shares in OCH by Taketa and the Rehabilitation Fund.
Sorry, you have gone back to
page 9 of the slides.
Page 9. Oh, okay. Thank you.
Again, the public protector did inquire into but did not complete an investigation on these issues. We would like to present evidence that fills the gap in that regard. And in relation to the purchase of shares and the involvement of the Bank of Baroda, we will present additional evidence of the business rescue practitioners who ultimately filed a report under Section 34 of the Corruption Act concerning how their suspicion arose in relation to that the acquisition of shares. Chair. I will not anticipate the evidence, but what you will hear also from the evidence of witnesses within Eskom that we'll call is that those shares were backed up by two forms of funding. The one was the use of a 1.6 billion rand guarantee that was given by Eskom for the benefit of Taketa, held in the custody of Absa Bank. That, of course, was not enough because the price was 2.5 billion. The balance was procured late in the day through an advance prepayment by Eskom to Taketa for coal supplies anticipated. Combination of both was enough to meet the purchase price and acquisition of those shares. What is key, Chair, is that when proof of funding was called, at that point in time, the Bank of Baroda became involved and gave the assurance to the business rescue practitioners that there is indeed this adequacy of funding, and the guarantee was presented as part and parcel of the proof of it. Again, that's an attempt to close the gap. And the next issue, Chair, relates to the Rehabilitation Fund. There has been lots of litigation around it. Part and parcel of the reports we'll present to you relates to the OTA, what do they call them these days? Organization Against Tax Abuse. Organization for Undoing Tax Abuse. I must confess I came across them in a different context when the acronym reflected something different. And it was an opposition of alliance to tolling. Yeah, that's when I came across them for the first time. But here, Chair, there has been all sorts of litigation. They have made representation to the Commission around matters such as those, and we will deal with it to the extent necessary, again, to close the gap. And Chair, that takes me to 5, investigate further whether any state functionary in any organ of state or other persons acted unlawfully, improperly, or corruptly in connection with exchange of gifts to the gift-linked companies or persons. Chair, at this stage, I would not want to suggest that we will close that gap in this round of the hearing. I can indicate to you that we have suggested a way forward about how we deal with this issue, and I'm not going to reveal here in public about the way forward.
Okay.
And 6, phase 1 of the investigation did not touch on the award of license to the Gupta family and superficially touched on the state financing of the Gupta-Zuma businesses while only selecting few states contracts. Further investigation is required. For the purposes of this round of investigation, Ms. Hoffman will deal with the Fontaine leg. Is that fair? And then, Chair, in page 10, the gap analysis concludes by the following commentary. The report guides this commission was key in identifying areas of investigation pertaining to Eskom. And let me give you a list of what we're going to converse in relation to other key investigation pertaining to Eskom. McKinsey/Trillion/Regiment, insofar as they deal with Eskom. My colleagues from Transnet will deal in detail with McKinsey/Regiment, insofar as it relates to
your colleagues dealing with Transnet.
Transnet, yes.
Yeah.
They will deal with the McKinsey relationship.
It's as if they are employed by Transnet.
No. My apologies, Chair.
Yeah, your colleagues dealing with Transnet, yeah.
Yes.
Okay.
It has been a long night. It will be a long day.
Yeah.
But my colleagues dealing with Transnet will explore the contractual relationship between McKinsey as the primary service provider for consultancy and related services to Transnet, together with its BEE partner, Regiment. For our part, and for the purposes of Eskom, we'll explore the relationship between McKinsey and Trillion, insofar as it relates to provision of services on 2 contracts, the corporate plan and the master services agreement. We'll explore that part. I've already indicated to you that we've asked McKinsey to assist us in that regard. The next issue, Chair, which we will deal with quite quickly, because it cuts across all different entities, It's a subject which we have dealt with when we looked at the various state departments, including GCIS, is the TNA issue. You have heard a lot about TNA's procurement of media buying business from GIS and the provinces. TNA also became involved in Eskom. There is a report which I'll take you to, which we believe that it is enough for the present purposes of closing the gap, which deals with TNA. It's a report from an audit and forensic company called Sizwe Nzaluba Gobodo, called SMG, and so we will refer to it. We are not going to suggest to you that that completes investigation. We mention it now in Eskom because it cuts across various other state-owned entities. Then Huarong will be the one that it's a new issue that we will ask you to note as additional matter of investigation. Then it will be the Fontaine and the OCM issue. And then, Chair, the key thing will be the relationship between Eskom's executives and third parties, which raises question from the emails that have been referred to in the report of Funduzi, that is chapter 3 of that report. I'll take you through it. And that is important because what comes out from those emails require further investigation in order to close the gaps. And then there will be, we would like to, at this stage, Chair, to note that there are question marks raised relating to the costs overrun for the Medupi and Kusile projects. At this stage, we as the legal team have merely noted them and have asked the investigators to look into it. Because from the Denton's report, it is quite clear that there are substantial costs overrun. We don't know what the precise explanation is. There may be a good explanation, we don't know. But there has to be some sort of explanation. Especially whereas here, one of the power stations' cost overrun is fourfold the original cost estimation. Chair, I mean, we are not project managers, we are not project analysts, but the very fact that the project overruns in terms of cost and time to 4 times than the estimate raises fundamental questions which the nation is entitled to ask and call for an answer. And Chair, those will be the areas that we will investigate, that we will deal with in the course of the gap analysis arising from the Public Protector's report. And Chair, unless you want me to deal with other issues arising from the Public Protector's report in terms of the gap analysis that we have done, we will then move to the next report.
Yeah, let's do that.
The next one, Chair, is the Denton's report. I have dealt with it, and I'm not going to waste your time by taking you through it. I merely would like to make some observations around the areas of investigation which Denton was required to investigate. They are set out in page 12 of the slides. And Chair, I merely ask you to know them. I'm not going to take you through them. And the key findings from the Denton...
I'm sorry. That's paragraph, that's page 12.
Page 12 of the slides?
Yes, okay. Yes.
The key findings are set out in page 13. And again, I'm not going to waste your time by taking you through them, except to ask you to know them. And then the next slide is page 14. And Chair, I'm not going to ask you again to waste time on them. And finally, the other comments that appear on page 15.
Yes.
And you'll see that the first comment relates to the snapshot when the investigation was cut short on the 18th of June 2015. And the second relates to the fact that there were no further verification and corroboration processes that Denton wanted to do in order to make sure that its findings are sound. 4, repeats the same concern that Denton could not guarantee the soundness of its conclusions. And lastly, Chair, I've added that you should also note the procurement deficiencies which Denton identified, which later became a problem. Chair, the next report is the Portfolio Committee on Public Enterprises. I had previously indicated to you that you'll find both reports in volume 3. And I'd like to take you to some aspects of the final report in volume 3 from page 984. Chair, is the gap analysis arising from that report. If you are at page 984,
Yes.
you will see that the Portfolio Committee makes several recommendations. And before I detail all of those recommendations, I would ask you to jump to page 985 in paragraph 4.13, because it reflects how the Portfolio Committee, in its wisdom, sought to fill the gap. And it says in paragraph 14.3, the Portfolio Committee recommends to Parliament to hand over this report, together with documentation, and the entire record of evidence collected in the course of the inquiry, to the Zondo Commission for further investigation.
Yes.
It is for that reason, Chair, we thought it wise to bring the record of the Portfolio Committee before you,
Yes.
because a very important organ of our elected representatives said that you must consider it for further investigation.
Yeah, no, it's very important, but I think even if they hadn't said so, as you know, already last year we had said that I wanted all reports that emanate from Parliament and other bodies that relate to the matters we are investigating, so that we could have a look and see what we can take and what can be of use to us and what might not be of use, and see where we might have to supplement.
Yes.
So it's in line with what we originally thought should happen.
Thank you, Chair. I see it's almost 1 o'clock. May I ask that we adjourn at this stage, because I'm going to get to matters of detail relating to the recommendations.
Okay, no, that's fine. we are going to adjourn for lunch and resume at 2 o'clock. The Commission adjourns.
Thank you, Chair. I am now pressed.
I must quickly do those files.